Think about it. I can see you all on your phones in the audience, okay? I know you're on them. They're basically an appendage, right? So don't we want this protected? And the Supreme Courts are like, yeah, we do. And that's really on display and kind of finally made really strong here in Carpenter. And this was the most recent case. And it says, it kind of marries that tracking plus cell data. And it says, look, your cell phone can track you. It can track you for like 11 years prior with this sensor vault stuff. This is really important, and the government can't just get this willy-nilly to do whatever they want. And because a cell phone faithfully follows its owner beyond public thoroughfares and into private residences, doctors' offices, political headquarters, and other potentially revealing locales, it deserves greater protection. It's crazy now how much data they can get and how close they can get to your location using that data. And Carpenter acknowledges this and basically puts to rest this third-party doctrine, okay? Originally, the law was, look, your phone records, your landline phone records, they aren't subject to Fourth Amendment protection because you submit them to a third party. There's Ma Bell who actually keeps everything. And so therefore it's basically public and there shouldn't be a warrant requirement. No, the Supremes are like, no. Unlike the nosy neighbor who keeps an eye on comings and goings, the telecom companies are an ever alert and their memory is nearly infallible, okay? This is the difference between like Mrs. Jones down the street watching you pull your car in and out of the driveway every day and Lord Sauron, the unblinking eye, right? Google is our Lord Sauron, the unblinking eye. Keep that in mind for those of you on your phones right now. So what do? Okay, we've got this evidence, it's novel, the government wants to use it. How do we fight this? Well, I'm sure that the phone won't be the only piece of evidence in your case. Hopefully not. If it is, well then you should have a good argument, and we're going to talk about that. But the first thing you want to do is you want to talk about your theories of defense in terms of this phone. So maybe, hey, that wasn't my phone, and there's some way to show that it wasn't your client's phone. That was my phone, but it wasn't me. I may have been nearby. I was going to Papa John's next to the bank that was robbed, but that doesn't mean I was at the bank. Or this evidence is completely unreliable. So the first thing you want to do is get discovery, okay? In my case, all of the raw data was disclosed along with the CellHawk reports. When you get your discovery, look, do you have the raw data? If not, you should get it. And in my materials, I've included a discovery request. Since I submitted these materials, I have another case, a homicide case, where they're trying to use this data, and we have now moved to disclose the source code. And if you find yourself in a situation where you also may be requesting the source code, or you want to, source code for CellHawk or for the sensor vault, email me and I'll share with you my pleadings that I've drafted. But basically, if any of you are familiar with the source code litigation that went on about the data master, I know it happened in my state, I don't know if it happened in your states, but basically, we're gonna ask for the source code and say, look, show me the algorithm that says that this is reliable. Show me. And where are your verification studies, and where are your reliability studies, and where are your, where's the data that says that there's nothing hacking this, or there's no bias or whatever. We don't have that.
If you want to talk to the police, go outside. What's the problem with that? Well, there's a lot of problems with that. But what's the real problem with that? To go outside, you have to open the door. And when you open the door, the officer can put his little eyeballs inside your house. So close the door. And there's some case law that tells us if you close the door behind you, you're better off than if you leave the door open. Because if you close the door behind you, then the officer can no longer see in. But if you're just holding the door open while you're talking to Officer Skippy, then he can look inside. And that creates a plain view situation. We're not going to talk a lot about plain view. The only thing I want to say about plain view is that the officer can't create a situation. Remember, a lot of times people say, well, they opened the door and they could see inside, so that's the end of it. It's plain view. It's like, no. Because if the officer does something that he's not allowed to do in order to create the plain view situation, it's still a bad search. And we're going to see this guy do it right now.
Don't tell me what I can and can't do.
This is my residence. You can't
There
step
he
foot in
goes.
my house.
Yes, I can.
No,
Right?
you can't.
I'm going to put my
Stay in
foot
the car
here
and don't
so you
cry
can no
about
longer
all
close the door.
Yeah.
So just remember, plain view is not the end of it. The exigency cannot be created by the officer. So you want to consider also the way doors work. Right? I told you I was going to talk for an hour about knocking and doors. Because you want to consider the way doors work. And this is really important. I had, in that hotel case, the officer said when he opened the door, it was just open, and they were standing there and talking. You guys all left your hotel rooms this morning. Did your hotel room door stay open? No, those things slammed shut. Mine almost killed me this morning when I was on my way out the door. And we had to have a maintenance person from the hotel come in and explain how the hotel door worked, right? So you want to think about how doors work, what way they open, do they open in or out? All those things could be important. And the best advice to clients, if they're knocking, don't answer the door. Nobody can get in trouble. If they have a warrant, they'll come in, right? All right. So let's take a moment for knocking. This is from an actual police Facebook post. And if this is an officer in your jurisdiction, you're going to want to keep that, but this is not about social media. So we want to remember, these are warrant searches. So I'm going a bit astray from consent searches, but since knocking is in the title, I felt a little licensed to do this. Knock and announce. We want to remember that there's 4 things that have to happen in a knock and announce. The officer has to identify themselves, verbally demand entry, give the occupants information about the scope of their authority, and give the occupant an opportunity to answer before they force entry. So that kind of goes like this. Police, open up, we have a warrant. And then the guy with the battering ram stands there waiting because he's excited. Because soon he might get to swing it. And how long does little Sparky have to wait? All right, so 20 to 30 seconds is sort of the range, depending on your jurisdiction. In New Jersey, we get like 30 seconds. Like, it depends. 20-second US versus Banks, 20 seconds was a close call, but okay, and it's a totality of the circumstances test. So we need to think about showing the judge that a longer period of time was what was reasonable.
If the legislature can say that just by the very act of driving on a given state's roadway, that a person has consented to a blood test or a breath test, why are we even talking about other exceptions to the warrant requirements in the case law? Why is Mitchell and McNeely even talking about exigencies? Why is Birchfield from 2016 talking about the search incident to arrest exception? If these laws do what they say they do, which they don't, but if they do, then why are we even mucking around with those other exceptions to the warrant requirement? Why do we need to spill any ink on those at all? If a person is consented by driving, boom, that's it. We're around the warrant requirement. We don't need to be talking anymore. The answer is one that we're all comfortable with because we're lawyers, which is it's not that simple, right? These laws, even though they say that they provide valid, actual constitutional consent, they don't do that, right? So that's the real reason that we're talking about those other exceptions. So this is the part of the Wisconsin implied consent law that was at issue in Mitchell versus Wisconsin, which was decided, I don't know, about half a year ago, last year, which is a person who is unconscious or otherwise not capable, maybe they're just too plastered, not capable of withdrawing consent, is presumed not to have withdrawn consent, meaning the law enforcement officer can just administer the warrantless non-consensual blood draw under this provision. And our state Supreme Court fractured like 3 or 4 different times and absolutely failed to develop any kind of binding precedent on this question, which I think is a really interesting legal question that our state utterly failed to answer. And so I was like, SCOTUS is going to have to take this. What I didn't know is that they were going to take it from a case from our state, right? And it got there because an assistant state public defender named Andy Hinkle personally wrote the cert petition and went to Washington, D.C. to argue that case, and he killed it. It was awesome to listen to that oral argument. But in any event, this is the legal question that is at issue in the Mitchell case, and it's the legal question that Wisconsin failed to answer 3 or 4 times, and that SCOTUS failed to answer 2. Right? We'll talk about why in a little bit, but essentially, despite the fact that the state had conceded that there were no exigent circumstances in the state court proceedings, the Supreme Court said, no, it was exigency. Right? Completely dodged the legal question. Extremely disappointing that they did it that way. So when we're talking about these implied consent laws, this is some language from a case from my state that's been cited, 12, 13 different other states. But it says that implied consent is not a descriptive or intuitive term. Said in English rather than judged, they don't do what their name suggests. They do something else, right? Doesn't mean that the police can force someone to submit to a blood draw. Doesn't mean that they've already consented. That's not what they're doing. They're doing something else, right? Instead of implied consent, maybe we should think of them as incentivized consent or induced consent, because what they really do is in situations where someone's been arrested on probable cause for an impaired driving related offense, can force them to make what is, for many of them, a very difficult decision, right? Consent and suffer the consequences of whatever's in your system, or refuse and suffer some different consequences, right? Either way, we got you. It's a Hobson's choice, a rock and a hard place situation. That's a difficult situation to be in. Depending on your state, there's either criminal or civil penalties to the act of refusal, and that complicates it even further. So it is a difficult choice. That's what the implied consent laws do. It is not conditioning your act of driving, right? The privilege of driving on your consent to a test. It's not really what it does. I guess it's conditioning it on, if you're arrested, we can put you to this choice, right? You don't have to consent.
Autopsy reports. Do you need to bring in the medical examiner who did the autopsy? If the person who testifies to cause of death relies on a toxicology report, do you have to bring in the toxicologist? Do you have to bring in the person who did the DNA? Or can they say, well, no, it's just something the expert's relying on as a basis for their opinion. It's not being offered for the truth. The other thing that comes up, the other explanation for this is that they say, well, I'm in charge of the lab, and I know what procedures Ms. Smith follows. And if you follow those procedures and come up with this result, I have an independent opinion based on reviewing this information and my independent information. It happens to be the same as Ms. Smith's. The question is, do you still have to call Ms. Smith? So why would it matter in autopsy? This person is Dr. Christopher Long. So in the Jensen case, he did testify. He was the toxicologist. And what he said was, after 2.5 years waiting for his opinion, and after he lost an 1.5 inch stack of files, he came back with the opinion that there were 22 ounces of contents in Mrs. Jensen's stomach, and that it was virtually all ethylene glycol. So many, many ounces of antifreeze in her stomach. Obviously, it doesn't naturally appear there. And he said it must be a homicide because she was so near death, she never could have drank all that antifreeze on her own. Okay, makes a certain amount of sense. On the other hand, if you do the math correctly, out of that 22 ounces, there was actually a 1/2 teaspoon of antifreeze in the stomach. It's really important to put your decimal points in the right spot when you're doing your math. And that's the kind of thing. In these cases, they would have loved to have just introduced Dr. Long's reports without calling him to the stand. What is the law on autopsy reports? Well, you have some courts who say, the medical examiner, when they do the autopsies, they're not necessarily looking to create reports for a criminal prosecution. That's their job. They have to decide what the cause of death is, and they do it. It's like an ordinary business record, and they're not looking to create evidence for a criminal case. Some courts say no, an autopsy is testimonial. Other courts say maybe it depends. If the person comes in with 47 wounds that look like stab wounds, the medical examiner might have an idea at the beginning of the autopsy that they're creating a report for use in a criminal prosecution. So these are the considerations. If you have an autopsy case or a toxicology case, you've got to preserve it, as I said before, because this stuff is constantly in flux.